I'm Dru Stevenson. This is for my administrative law class. Here I'm going to be talking about one of the exemptions to the Freedom of Information Act and its disclosure requirements. This is Exemption 1, which relates to national security information. So let's dive in. So the Freedom of Information Act requires government agencies, as a general rule, to disclose information or documents upon request, subject to some big exceptions, and those are delineated in 9 categorical exemptions for different types of information under the Freedom of Information Act in 5 U.S.C. 552. Exemption 1, I think, is pretty intuitive, that the government wouldn't have to turn over national security secrets and so forth. But let's look at the specific wording of the provision here, because it's carefully chosen language. It says that the disclosure requirements do not apply to matters that are specifically authorized under criteria established by an executive order to be kept secret in the interest of national defense and or foreign policy, and are in fact properly classified and pursuant to such an executive order. So not every document related to national security will come under FOIA Exemption 1 automatically. There has to be an executive order that sets forth criteria for designating certain documents as classified, classifying those documents. And those documents have to have gone through whatever the process set forth is and have to meet the criteria in that executive order. In other words, they are in fact properly classified pursuant to the executive order. Apart from the specific language, though, the general idea is that information could be classified if its unauthorized disclosure could lead to damage to national security, including defense against transnational terrorism. I think courts are pretty deferential to the federal government under Exemption 1. At least historically, courts generally give substantial weight and significant deference to agency affidavits and expertise regarding the national security classification decisions themselves. Now, sometimes classified information has been leaked by, let's say, a whistleblower or something like that, or just through the rumor mill. And the question is, how does that affect FOIA Exemption 1? And the answer is that for classified information to be considered already public or in the public domain, such that it would lose the protection of FOIA Exemption 1, it must have been, quote, officially and documentedly disclosed, not merely leaked or speculated upon. Historically, executive orders that basically talk about classifying documents have recognized what's called a Glomar response. And we have a case in the casebook that I use in my course that's all about the Glomar doctrine. And Glomar responses are the sort of classic refusing to confirm or deny that certain records even exist or are in the possession of an intelligence agency. There's also a sort of parallel theory called the Mosaic theory about classifying compilations or otherwise unclassified information that they could then become a classified compilation of documents that were previously unclassified. It's important to keep in mind, though, that agencies are generally required to segregate and release any reasonably segregable non-exempt portions of the documents. That's where you get these sort of classic redacted documents that have certain lines and names blacked out, even if other parts of the same document are properly withheld under Exemption 1. I have a few examples of Exemption 1 in the courts in recent years that I thought might be helpful for me to just kind of summarize for you. The first is Judicial Watch Incorporated versus the U.S. Department of Defense. This is from the D.C. Circuit Court of Appeals in 2013. And here the CIA successfully invoked Exemption 1 for classified material to preclude the disclosure of post-mortem images of the preparation of Osama bin Laden's body for burial and details about the burial itself. In this case, the Judicial Watch versus the DOD case, the release of the images, the government argued, could harm national security. The CIA described prior instances in which sort of analogous disclosures had led to widespread riots and fatal violence overseas. And so withholding these images of bin Laden's body, his dead body being prepared for burial, was not to shield wrongdoing by the government, they claimed, or to avoid embarrassment, but just to prevent a backlash against it, that it would be provocative and would lead to more violent attacks. The next example I want to give you of FOIA Exemption 1 in the courts is a 2017 case from the D.C. Circuit Court of Appeals, and this is the Center for Public Integrity versus the U.S. Department of Energy. The Department of Energy was investigating a government contractor for illegal lobbying activities, and it justified refusing a FOIA request by invoking multiple exemptions, including Exemption 1. In this case, the information that the Department of Energy didn't want to disclose about a contractor pertained to security measures for a nuclear laboratory that was operated by the contractor, techniques about detecting missile attacks and vulnerabilities in government nuclear programs. And I think it's pretty easy to see why they would have invoked Exemption 1 and claimed that it could be a threat to national security to reveal the vulnerabilities in our nuclear programs or how we detect missile attacks and where our nuclear labs are. The next quick example I have for you about FOIA Exemption 1 is a federal district court case from D.C. in 2018, Bin Ali Jaber versus the Department of Defense. This was a FOIA request for documents related to an alleged drone strike in Yemen. I have a separate video about a different case related to CIA information about drone strikes. The Department of Defense and other agencies the court held here were not required to set forth classification level requested records. In other words, they didn't have to turn over the classified documents. The department did not need to state which classification level the documents were at in order to say truly that the information was classified. That was part of one of the kind of thorny issues to sort out in the case. Is it enough for them to explain to the court that these specific documents are classified, or do they have to disclose the specific? There are different levels of classification. Do they have to disclose that? And the court said they don't have to disclose classification levels. And then I have one last quick example for you of FOIA Exemption 1 in the courts, and this is from the Southern District of New York Federal District Court from 2020. It's the Civil Liberties Union, or ACLU, versus the Department of Defense. And the court here said that the FOIA Exemption 1 still applied to classified portions of emails about covert military operations, even after there had been an official acknowledgement of some of the information contained in the emails. Now, in this case, ACLU versus Department of Defense, the government had made some disclosures to the court to try to prove their case about that Exemption 1 applied. The Department of Defense declarants had stated in sworn affidavits that the information withheld involved discussion of military tactics and strategy that would be far more revealing than prior acknowledgments of general facts. So the documents being requested were too specific about their military tactics and strategy. And that wraps up our quick overview or introduction to FOIA Exemption 1. Thanks for watching.